Hi, this is David Bliven, Bronx and Westchester divorce attorney with another episode of Lessons from the Divorce Wars. So, in the relative recent past, I had a potential client come in and relate to me the instinct of a lot of people. I want to save money. I don't want to spend a ton of money on my divorce lawyer or my divorce. So her instinct was, I'm going to not hire a divorce attorney for what I deem to be the simple stuff, which is, kind of going into court, accessing the office of the self-represented, and having them do the answer for her and get it filed with the court. And if she's watching this, you know who you are. Because as I told her, here's the problem with her doing that and not having that answer reviewed by a good divorce attorney. So the Office of the Self-Represented, no offense to them, they just did a bare bones answer. They e-filed it for her. You're going to see a lot more of that, by the way, now that they are making e-filing mandatory in almost every single county of the state of New York. So you're going to see a lot of quote-unquote pro se people filing their own stuff, not having it reviewed by an attorney before they do it, and unwittingly giving up things that they're entitled to. Don't do that. So, in her case, again, bare bones answer, got it filed. Months and months went by. 6 months, I think, went by. Came back to me, and I took a look at the answer, and I said, well, gee, you have custody of kids. Did you assert a child support claim in the answer? And the response was, no, I don't think I did. And I gave her the bad news. Here's the problem. You were entitled to child support, but only retroactive to the day you filed your claim within your answer asking for child support. If you did not include that claim in your answer, you waived child support going back to the date of your answer. The only thing the court could do in almost every instance is to award child support going forward from the date of the settlement, or if it's a contested case and you made sure to assert that claim in the preliminary conference order, could be theoretically retroactive to the date of that PC order. But in her case, that wasn't done. No claim was asserted. And here's what she missed out. My guesstimate was the soon-to-be ex-husband owed her ballpark about $1,000 a month. Well, if your case was pending for 6 months, you just gave up $6,000 that you would be statutorily entitled to. Don't do that. That's the bottom line. Don't, even if you think, I'm pricing out a lawyers rather, I can't afford them, have a consultation with one. Bring in the documents, even if the Office of the Self-Represented draws it up for you. Don't file it yet. Don't tell them to file it. Instead, take the document back, say, thank you very much for drafting this for me. I appreciate it. Call attorneys. Set up consultations. For most attorneys will not give you anything for a free consultation, but the good attorneys, for a relatively low cost initial consultation, will take a look at the documents that you're proposing to file with the court and say, yeah, that doesn't look right. Here's something you might want to change or add to before you file it. Good advice. Get it. That's the lesson. So if you're looking for similar answers to questions like these, check out my blog, You'll find it at blivenlaw.net/blog. See you next time.